Right, so I think we're gonna. Should we? Do you want to say a few words, Emma, before we or Ali, before we dig into it?
Good morning, everybody.
Good morning.
Brilliant to have so many people on the call this morning interested in this subject from such a wide variety of sectors. Lovely to have so many HR professionals on the call. My name is Alison Watson. I'm Head of Client Services for Juice Recruitment, and I'm sat with Emma Summers today, the CEO and founder of Juice Recruitment. So yes, absolutely can't wait to get stuck into the nitty-gritty of neurodiversity. And as Tim's been saying, not necessarily just to support that, but to have potentially to accommodate that within the workplace, and also very much optimize and maximize those skills as talent, which is key to Juice. So very much back over to you, Tim, but also just to say, do use the Q&A box throughout. Later on in the session, we will be coming back to answer those questions. So do feel free to ask questions throughout using the box.
Oh, thanks.
Yeah, thank you, Ali. Yeah, put your questions in the chat, and we'll, like we did last time, we'll wrap them up at the end. Okay. Morning, everybody. Neurodiversity in the workplace. I'm going to chunk today's presentation up into three areas. Okay, so the first area is language and barriers in the workplace to effectively integrating those with neurodiversity into our workplaces. We're then going to be looking at some cases, some good, some bad, and some ugly. Things that have been done right, things that haven't been done right, and give you some tips about how we, some guidance as to how we can do things better in future as employers. And third section, we're going to looking at some practical guidance to help neurodivergent employees thrive in the workplace, like Ali said. So language and barriers, cases, and some practical guidance. Okay, I am joined today by my colleague Charlotte Marshall. Charlotte joined us in the employment team based here in Bath at the beginning of September. So Charlotte is 24 days into her RWK Goodman journey, and doing a brilliant job so far. We're loving having her in the team. Charlotte came from the big smoke. She's now come for a bit of peace and quiet in the suburbs. And she'll be talking to you a little bit later. Okay, the slides today, they're quite long. They're meant for a bigger presentation. And I've deliberately done that because what I'm going to do afterwards is I'm going to send the slide deck out to you all so you can see what we've been talking about. I may gloss over some areas because there is a lot of slides. But as I say, you'll get the slide deck afterwards. So, first of all, the rise in neurodiverse diagnoses, it's pretty profound. Did you know around 1 in 7 people in the UK are neurodivergent? 1 out of 36 children have autism. What I didn't know, at least 1 in 17 people are thought to be dyspraxic, which is it's a condition which affects your mobility, your balance. And 1 in 10 people in the UK are thought to be dyslexic. So we all work amongst people in our workplaces who have some form of neurodiverse diagnosis. Big question, first question, what is neurodiversity? Well, the definition from the Royal College of Nursing is neurodiversity is an umbrella term that describes the differing ways that people's brains process information. I like this definition. It's quite straightforward. It's quite simple. And it says what it is. Let's repeat it again. Neurodiversity is an umbrella term that describes the differing ways that people's brains process information. I guess the first thing to say is we are all neurodiverse. We all process information in different ways. So I think it's a bit misleading to say, that certain staff, such as those with autism, are neurodiverse. I think that's wrong. I think we're all neurodiverse. Some of us just have different traits, the way we learn, the way we think, compared to others. I mentioned at the beginning that language is a really, really key part of making those with neurodiversity feel welcome in the workplace and getting the most out of them. So it's really important that we understand some key terms and language. So what is neurodiverse? Well, neurodiversity refers to collective variations in the human brain and condition that deal with sociability, learning, attention, and other mental functions. It's a group trait, not an individual trait. And individuals are often mistakenly described as neurodiverse. But here's the key point. Neurodiversity includes everyone, so we're all neurodiverse. However, some are neurodivergent. So the correct description we should be using for an individual who has autism, dyspraxia, dyslexia is neurodivergent. What it means is it's somebody who, it simply means a person who has a neurology, a mind, which differs or diverges from the dominant social norms. Okay? So the correct terminology should be somebody who's neurodivergent. They differ from what society sees as the normal way of the mind functioning. Now, we'll come on to a minute to say there's nothing wrong with this. And in fact, those who are neurodivergent are very keen to point out that I'm not different. I just learn differently. I think differently. Third term is the term neurotypical. The neurotypical is the opposite of neurodivergent. A neurotypical brain is one that does not display characteristics of developmental differences or atypical patterns of thoughts or behavior. But what neurotypical doesn't mean is normal or, for example, not autistic. Neurotypical purely means that you share a style of cognitive learning and functioning with the dominant social group in society. So I think it's really important that we know what those terms are. Neurodiverse, we're all neurodiverse. You've heard this phrase, everybody's on the spectrum. We are. We're all neurodiverse. Neurodivergent, those individuals in our workplace whose mind differs or diverges from the dominant social norms, and neurotypical, which is the opposite of neurodivergent. So what's the language we should be thinking about in our workplaces when we have people in the workplace who we know are neurodivergent? The first thing to say is that it's really important to use first-person language. Those who are neurodivergent really, really like this. And it's a way of making them feel valued, comfortable, accepted in our workplaces. We've seen the use of, or the change of language in relation to pronouns. And I think what we need to do as organizations is be thinking about, well, how we address people with neurodivergency. And the important point is refer to them in the first person. For example, people with a disability or people with dyslexia, rather than disabled people or dyslexics. Equally, someone is autistic and they don't have autism. They're autistic. It's who they are. It's their trait. It's their personality. It's them. It's their person. People with neurodivergency don't think or don't see themselves as having any condition, any problem, any issue, because they don't. They just process the world in different ways to us. And we need to make sure that we don't treat them any differently. So those with a neurodivergence don't like the term condition. They don't like the term difference. They don't like the term disorder. The medical definition of neurology doesn't actually fit properly with a modern way of looking at the world, and those with a neurodivergent trait. We need to avoid negative or medicalized terms like suffering from, because again, those with a neurodivergent trait don't believe they suffer from anything. They're the same as you and I. They can do the same job. They just process the world in a slightly different way. They don't suffer from anything. And this is a really important one. Employers should also avoid the use of the term learning difficulties, because this phrase is more commonly associated with children. A lot of children, as they're growing up, as they go through school, they realize they're not learning in the right way. So they go and see somebody to find out why they're not learning in the right way. So learning difficulty is not a term that we like to use for those in our workplaces that are neurodiverse, because it is more commonly associated with children. And I think they don't like the word learning difficulties because they don't struggle to learn. They just learn in a different way. And I think this is a really, really key point. Whatever you throw at them, they can do. They just may need to learn it in a slightly different way to those people who are more neurotypical. And the last bullet point on this slide I think it sums it up pretty well. When I heard this from somebody I was talking to last year, and they were getting a little frustrated. They had dyslexia, and they say, my dyslexia is not a disorder, it's who I am. I'm no different to you in many, many respects. I just need help in getting through the workplace. And if you help me in a slightly different way to the neurotypical person, I will excel for you. And we worked very closely with that individual, and she did excel. Absolutely, she excelled. So it's not a disorder, it's who I am. So language is really key, not only to make people feel inclusive, but also to ensure that we accept people for who they are. Okay, Charlotte is now going to talk to you a bit about the law and when neurodiversity is considered a disability. Over to you, Charlotte.
Thanks, Tim. So when is neurodiversity considered a disability? The Equality Act 2010 provides protection against discrimination for individuals with disabilities, and that can include some of those who are neurodivergent. Under the Act, a disability is defined as a physical or mental impairment that has a substantial and long-term adverse effect on their ability to carry out day-to-day activities. Now, to just unpack this a little bit more, a substantial adverse effect has been deemed to be more than a minor or trivial impact on someone's life or how they do certain things. Whilst day-to-day activities can include all the usual types of things that individuals would do in their work or personal lives, using a computer, reading, writing, communicating with people, and so on. And long-term effect, well, most types of neurodivergence will be a lifelong impairment. So most neurodivergents will meet that section of the disability. Crucially, it's important to remember that the absence of a medical diagnosis does not prevent someone from being disabled under the Equality Act. And not all neurodivergent people will even see themselves as disabled. As Tim said, a lot of these conditions, they exist on a spectrum, and so not everyone with those conditions will be disabled, but some individuals will. So it really does depend on the impact that it has on their day-to-day activities and how they are in their personal lives and at work, as opposed to the kind of medical labels that are put upon that. And employers should be cautious about making assumptions based on experience with other employees with the same or similar conditions, or based on their own general knowledge of a particular condition. So next slide, please, Tim. So just to continue with the legal framework then, the Equality Act protects individuals from a number of types of discrimination, and these are summarised at the top. So we have direct discrimination, indirect discrimination, harassment, victimisation, discrimination arising from disability, and a failure to make reasonable adjustments. And reasonable adjustments are necessary where the neurodiverse condition amounts to a disability. And this can include a range of things such as modifying workstations, allowing flexible working hours, adjusting communication methods, and so on. And it's also really important for employers to consider reasonable adjustments during recruitment and promotion processes, and what might be necessary as part of those processes. Okay, next slide, please. So what are the barriers that may be faced at work for neurodivergent people? And I've split these into two main headings. So we've got kind of lack of awareness and understanding from colleagues, as well as the office environment itself. So lack of awareness and education. This can lead to bias, assumptions, and stereotypes about neurodivergent individuals, and misunderstandings about neurodivergence mean that people may not feel safe to talk openly about their differences or how they experience the workplace differently, and that can create a general sense of mistrust within the workforce. Line managers and supervisors, they may incorrectly think that an employee is incompetent or incapable of the work without having understood more about their background and skills. And likewise, other colleagues may perceive someone as chaotic or disorganized due to how they approach their work tasks. And this can lead to a person's unique strengths and talents not being properly utilized or even recognized. And so it's really important that we think about different ways of working and different approaches, so that neurodivergent individuals can be properly appreciated and valued, and ensure that innovation and creativity isn't stifled, as you know, different individuals with different brains can bring all sorts of different things to the workplace. So we want to kind of harness that as much as possible and ensure that everyone's potential is fully utilized. And then the second heading here is the office environment. So noisy open plan spaces can be very triggering, as can other things that crop up during the working day, such as last minute changes to plans or daily routines, and things not providing timings or materials in advance of meetings, so that people with neurodivergence know what to expect and can prepare properly. And I think it's really important for organizations to just generally think about how neurotypical norms are often baked into our organizational systems and processes, and how these can perhaps be altered or adjusted to ensure that they work for everyone within the office environment. I think it's next slide down.
Lovely. Thank you, Charlotte. So before we move on to look at the cases, I'd just like to flag up with you the rise of cases coming through the Employment Tribunal that have neurodivergent tendencies and basis to those claims. We are starting to see many more claims come through where people are claiming disability discrimination based on a neurodivergency. So you can see from the table here that since 2015, when there were no recognized cases through the tribunal that refer to either autism, ADHD, or dyspraxia, the occurrence of these sorts of claims has steadily increased year on year. In 2024, tribunals heard 102 cases where neurodiversity was specifically cited as a factor in alleged discrimination, which is a 46% increase compared to 2020. I can't see this trend reversing at all. If anything, I think that table is going to go up, because as we train more people in what to look out for, how to manage neurodivergency in the workplace, people will feel more comfortable about raising it And if people raise it, we have to deal with it. If we deal with it badly, that could lead to an employment tribunal claim. Generally, it is now more socially acceptable to raise neurodivergency in the workplace. If that's the case, then that will mean that more people feel more comfortable about standing up for their rights, whether that's a grievance or whether that's an employment tribunal claim. This trend in the table is only going to go up. So it's something we really do need to get our minds around, and we really need to think about how we are not going to be one of those statistics facing a tribunal judgment at Bristol Employment Tribunal, having lost a claim of treating somebody or harassing somebody, for example, because they've got autism. Okay, so that's the first section done. Charlotte and I are now going to talk about 3 cases. I'm going to do the first case. And the cases, well, the 3 cases, we've got one where an organization messed up selection tests. We've got one where it was a good example of how not to deal with persistent complainers in the workplace. And we all have some of those. And the third case is an example of how dismissal of somebody who is neurodivergent can be found to be fair, although there's a sting in the tail with this one when it comes to harassment of that individual. So, okay, let's look at the first case. The first case I'm going to talk about is the case of the Government Legal Services, which I'll abbreviate to GLS, and Miss Brooks. So I guess the first thing I want to say is our judges often get charged with being too old or too out of touch. I personally think we have the best judges in the world. And I can tell you, having dealt with a number of cases and talked to tribunal user groups, that judges are not out of touch with real life in the tribunals. They do have very good training, and they are very aware of neurodivergency. And they are very aware that, as Charlotte said, on a lot of occasions, it can be seen to be a disability. So they will stand up for individuals' rights. It's not something they haven't been trained on. They're too old to understand. They're of the wrong age group. They know about it. So we need to be aware that it will be tackled in an employment tribunal. So case study 1, Government Legal Services and Brooks. This is a case where a tribunal decided very firmly on the side of the employee, Miss Brooks. Miss Brooks suffered from Asperger's. So she was a law graduate. She did her training. She was looking for a training contract, and she applied to the Government Legal Services. Government Legal Services takes on a large number of trainees every year and trains them, and they become solicitors. That's a very good job, very interesting. You can enter in some very interesting areas of the law. However, the first stage of the GLS process was a multiple choice judgmental test before anybody got to interview. Miss Brooks said to them at the application stage, I have Asperger's, I struggle with multiple choice. Can we change this, please? I really like the GLS. I really want to work for you. Could you change it, please, so that I have a fairer chance of passing and getting through to the interview stage, where I think if you look at me, you'd be impressed. I will make a great lawyer. In a rather short-sighted way, the GLS said no. Okay. They said to her, you'll get more time for tests later on if you pass this initial section, but I'm afraid we're not going to change this multiple choice test for this initial SIF. So Ms. Brooks is an aspiring lawyer. What did she do? Quite rightly, she went to a tribunal. She brought a claim for indirect discrimination and failure to make reasonable adjustments. The failure to make reasonable adjustments is obvious. Why didn't you make an adjustment to the initial selection process for me? The indirect discrimination is under Section 19 of the Equality Act. We've talked about this in previous hubs. What it basically means is somebody, some organization, some business puts in place a provision, criterion, or practice, and here it was the practice of only making people do multiple choice tests to see if they got to the next stage. So she brought a claim of indirect discrimination. She said, because of that practice you put in place, I, as a woman with Asperger's, was put at a disadvantage, and the disadvantage was I wasn't going to perform well multiple choice, therefore I wasn't going to get through to the next round, and that's wrong. So the GLS, not surprisingly, lost at the employment tribunal. A little bit embarrassing for the GLS because it's full of employment lawyers. One of the biggest GLS legal government departments is employment law, because the government employs a shed load of people and a shed load of, local employment, local council people, etc., bring claims. So in tribunal, the GLS said, well, we didn't want to change the testing method because of the application of the subjective human judgment. Okay, we didn't want somebody looking at the SIFT stage to see who was going to go through to the next stage, because we thought human subjective views may skew that process. We want to keep it really binary, really simple. Do you pass, don't you pass? And they also said that it would be too expensive to have a more involved process for Miss Brooks if they were to change the process for her. So we know from previous HR hubs, when we're dealing with this indirect discrimination, this process you put in place that affects me as a disabled person, we know that there's kind of a two-stage test to this to see whether there has been discrimination. Number one, has there been, is there, on the face of it, some form of discrimination? And some employers will actually accept that in tribunal and say, yes, there was. Some will say, no, there wasn't. In this case, the GLS said, no, there wasn't any form of discrimination. And the tribunal said, well, I don't agree with that. Okay. And they said, I don't agree with that for two reasons. They looked at the test of indirect discrimination, and they said, although I understand why you wanted to only have multiple choice tests to take out that subjective human element for the decision making, and they said, I get that, I understand that, tick GLS. What you didn't do is you didn't pass the second part of the test. And what you haven't persuaded the tribunal that was that the process you put in place by refusing Miss Brooks to do something different to multiple choice was a proportionate means of achieving a legitimate aim. And we've come across these terms before, haven't we? Legitimate aim, what do you want to do? I want to stop the subjective decision-making element getting into my process, and therefore I want it to be fair. Tribunal said, yeah, I get that, that's fine. But what they then went on to say was, well, that is not proportionate. Okay, proportionality means, is there something less discriminatory that you can do to put that disabled applicant on an equal footing with other applicants? And the tribunal quite rightly said, this is the GLS, a very big organization. Yes, you could have done something else to help Miss Brooks, and what you should have done is given her the opportunity to not do the multiple choice, but to actually do some form of other test, a written test. And then you should have ensured that there wasn't that element of subjectivity. So it wasn't proportionate. Basically, the discriminatory effect on Miss Brooks was more than the impact it would have had on the GLS to actually change their processes. So they lost. They also lost on the basis of it was a reasonable adjustment to change that initial stage. And an important point to make is, if a tribunal ever find that you could have made a reasonable adjustment, whatever policy, procedure, or criterion, whatever PCP you put in place, you are never going to win a claim of indirect discrimination, or rather defeat a claim of indirect discrimination brought by one of your employees. So they should have made reasonable adjustments. They didn't. They should have changed the policy. They didn't. They lost. Went to the EAT. The EAT agreed. The final point I'll make on this case is that, and we need to think about this in the round, employers are not expected to lower recruitment standards or make tests easier for those who are neurodivergent. It's that level playing field we need to create. But what they must have is equal access to opportunities, promotions, whatever they have in the workplace, or whatever there is in terms of recruitment. They're not expected to lower recruitment standards or make tests easier for those who are neurodivergent. But these are the key words. Equal access is a must. And the last point, whenever you are recruiting somebody, it's always very sensible to ask them. I'm sure most companies do this, but always ask candidates if any reasonable adjustments need making. I don't think in this case that the GLS asked. Miss Brooks had to raise it with them, so they're already on the back foot. Okay, so that's the case of GLS versus Miss Brooks, a case on how not to do recruitment and selection tests. Case study 2, I'm going to hand over to Charlotte, who's going to talk about the case of Wright and Cardinal Newman Catholic School.
Thanks, Tim. So this is a 2021 case of Mr. Wright and Cardinal Newman Catholic School. I think to encapsulate this case, it's one where you have an employee who is raising numerous grievances, and the relationship between him and his manager has really broken down. And so a fairly kind of typical set of events, I suppose, that many of you will have seen perhaps in your workplaces, where, you know, over time the relationship is just breaking down, more grievances are happening, disciplinary issues and so on, and it kind of reaches that kind of cut-off point where something's got to give. But I think the crucial aspect of this is that the claimant was neurodivergent, and that wasn't properly taken into account by the school during that kind of 3-year process. So to start off with a bit of background, Mr. Wright was a long-standing employee, and he was the head of maths. He had a number of disabilities, including autism, specifically Asperger's syndrome. And the whole kind of sorry tale started because he believed that he had been victimized as a result of giving evidence in support of a former colleague who had brought an employment claim against the school. Following this, and it's also important to note, I suppose, that a new head of the school had also come into the school at this time, which I think led to the breakdown in relationship between the head and Mr. Wright. He had raised a number of grievances then over a 3-year period, and during this time period, he was also suspended by the school and subjected to a disciplinary process, which was whether he could continue to work into the school due to what was described as an irretrievable breakdown in the relationship between himself and the new head. And it was also at this time that he was diagnosed with Asperger's syndrome, which he informed the school about, and the school correctly instructed experts to consider what reasonable adjustments needed to be made to facilitate his return to work in his role of head of maths. And following this expert report, the school then offered him a completely different role, which it packaged as a reasonable adjustment, but was effectively a demotion. Mr. Wright rejected the offer, and the school responded by giving him an ultimatum: you either accept the offer or we dismiss you. Mr. Wright at this point tried to save his job and said that he would return, but he would only work under protest. Following this, there was kind of more back and forth between the two parties, and the school concluded it was not possible to reach a mutually acceptable resolution and terminated his employment on notice. Following this, Mr. Wright submitted a claim to the tribunal for unfair dismissal, victimization, discrimination arising from disability, and a failure to make reasonable adjustments. Now, Mr. Wright's claim for failure to make reasonable adjustments did fail on the basis that he had not returned to the school following his suspension, and the school had shown that it was amenable to making adjustments and had discussed them with him during his suspension. And for the claim of discrimination arising from disability, now to succeed with this claim, Mr. Wright needed to show the tribunal that it was his repeated grievances and the manner in which he went about these that resulted in his dismissal, and that they arose in consequence of his autism and or other disabilities. Mr. Wright, in the course of the tribunal proceedings, provided an impact statement, and in this he described the effect of his disability on his behaviour. And specifically, he said that this caused rigidity of thought, particularly in terms of his thinking around what's right and what's wrong, obsessional traits, and difficulty in social interaction and communication. In this case, the tribunal looked carefully at the evidence, and they concluded that the behaviours which led him ultimately to him being dismissed did arise out of his autism. And so his claim for discrimination arising from disability succeeded, as did his other claims for unfair dismissal. Now, the parties reached agreement about the amount of compensation that Mr. Wright received, and he agreed to accept $850,000, which included $750,000 for injury to feelings and loss of earnings, pension losses, and interest. Now, in this case, the school did make a number of mistakes, but crucially, in terms of our discussion on neurodiversity today, it did not make any allowances for Mr. Wright's neurodiversity in terms of how it dealt with his grievances and how it treated him during the disciplinary process and his suspension. And this case really highlights that it's really important for employers to make an effort to understand how autism or another neurodivergent condition may impact an individual's behaviour, and know when to ask for help, preferably at an early stage to avoid problems escalating. And just to reference what we were discussing earlier as well, all different types of neurodivergency obviously impact everyone differently, so we cannot have a one-size-fits-all approach. It's all about the impact on that individual. So whilst you may have an employee who also suffers from autism and some particular reasonable adjustments or whatever have helped them, that might not be the case for another employee who also has autism. So it's important to really understand the impact for each individual. And this can also include obtaining medical or occupational health evidence or assessments, which can help employers in assessing how best to understand the individual and the impact that their disability has on them. Thank you. Next slide, please.
Lovely, thank you, Charlotte. Okay, case study 3. This is the case of Miss Morgan and Buckinghamshire Council. So Miss Morgan was a social worker in the fostering team within the council. She had autism and dyslexia. Now, because they were dealing with children, the council had a very clear policy on gifts and other related issues relating to how you deal with children who need to go into care in the fostering team. And the policy was very clear that nobody should ever bribe a child or give gifts, because that could then be seen as some form of grooming. It was effectively a risk prevention strategy, and it's common within councils. The key point here is that Miss Morgan knew very clearly what this policy said, and she knew she shouldn't bribe anybody, in particular kids. Unfortunately, she did give a gift to a child who she was responsible for. She was responsible for finding a care home, a fostering home for them. And she also wrote up meeting notes, which largely consisted of her own thoughts and feelings, and this was very much against council guidance. Had to be very objective, rather than having individual thoughts or views injected into the fostering process. So the council found out about the gift and the notes, and they held a disciplinary and they dismissed her. She appealed, and that was not upheld. They dismissed her on the basis of misconduct. An important point to note is that the appeal manager who held her appeal said in the outcome letter, quote, "It's a matter of serious concern that Miss Brooks had chosen to mask her autism throughout much of her employment, potentially putting children at risk. Okay, and we'll come on to this in a minute because it's key for this case. So Miss Morgan went to tribunal and she claimed unfair dismissal. She also claimed harassment on the basis of her neurodivergency. Now, what I want to do here is contrast this case with the early case of Brooks, okay? Because one of the Miss Morgan brought the case of harassment, and again, we look at the test of whether it was legitimate and proportionate to take the steps which the council did before they dismissed her, and was it discrimination on that basis? So, as a reminder, employees must take effect of the disability into account. They did here. Miss Morgan knew the policy was in place. She knew why she shouldn't give gifts to children, yet she still went ahead and did that. The tribunal were quite quick to point out that this was clear misconduct. She knew what she shouldn't have done, and she did it. So she lost the unfair dismissal claim. The council succeeded in defending that. When they looked at the discrimination claim, the harassment, they then looked at whether what they had done in dismissing her, was that a legitimate aim, and was the sanction proportionate? So we can see the same terminology running through here that we had for Miss Morgan. So the outcome of this case was very different for Miss Morgan. What the tribunal found, that there was a legitimate aim for dismissing her, even though she had autism and dyslexia. And that legitimate aim was the protection of children. The tribunal very quickly found that, yes, that is a legitimate aim, something you are trying to do. And if somebody steps over that boundary, then that in itself can be a legitimate reason to dismiss somebody, and a fair reason. So they then moved on to the second part of the test, which is whether what they did was proportionate. To contrast this here with Miss Brooks. Miss Brooks, the lady who wanted them to change the first part of the interview, wanted them to take away multiple choice, put something in place. There they said, refusing to change for Miss Brooks was not proportionate, so she won her claim. Here, what the employment tribunal said was that the dismissal was a proportionate sanction. What it said was the council couldn't be sure that Miss Morgan wouldn't do the same again to another child, because she knew what she shouldn't be doing. She knew she shouldn't be bribing any children. And the tribunal were persuaded by the council that, yes, we accept that Miss Morgan has these neurodivergencies, but she knew the policy, and we couldn't be sure that she wouldn't do the same again. And to us, that non-bribing, that protection of children is absolutely paramount. So they persuaded the tribunal that the dismissal was actually proportionate in this case. So we'll see it all comes back to rationale, reasoning, arguments. If you have discriminated and you have got a discriminatory policy in process, here it was the non-gifting to children. If you've got a process in place, you may lose on that first head. Was it discriminatory? Yes, but you could succeed on the second head, which is, was it legitimate and proportionate? And as I said here, the council did succeed in defending the discrimination claim on that basis. However, Miss Morgan did succeed in one particular area, quite a fine area. And this relates to the harassment point I made earlier. If we go back, we look at what the outcome manager said in the letter. this is a matter of serious concern that Miss Brooks had chosen to mask her autism throughout much of her employment, potentially putting children at risk. So this is the basis of Miss Morgan's disability harassment claim. What the Employment Tribunal found was that one line in the outcome letter did actually amount to harassment, because what the outcome manager had done was effectively made a decision, made a judgment based on what he'd seen without any backing up of that decision or judgment. If the appeal officer had stuck to the facts and said, I understand why the council in the first place dismissed you, and I think the grounds they used were correct, if he'd stopped at that, they would not have lost on the harassment point. However, he went one step further, and he put a line into that outcome letter which was subjective, and it made a decision in his own mind as to what Miss Morgan had done, and it was without substance. It was without being, he couldn't back it up. So the tribunal found that one line constituted harassment of Miss Morgan, and on that basis she won that discrete point of disability discrimination harassment. So that's the sting in the tail for this case. I want to flag up very quickly a fourth case. I'm not going to talk too much about it, but it was brought to my attention by Gabby in our team last week. It's just come out. It's in itself is not a particularly significant case. The facts are nothing that we've seen before. But the important point about this case, and it's the case of Lloyd Penny and the Automobile Association. The point I want to flag up about this case is the recommendation which the tribunal made when Mr. Lloyd Penny won his claim. Now, recommendations are, in addition, compensation, reinstatement, whatever it may be, and recommendations can be quite broad. Here, Mr. Lloyd Penny won his disability claim based on his neurodivergency, and the tribunal awarded him a fair amount of compensation. But what the tribunal also said to the AA, this is the recommendation, was that the AA needed to write to him in the 2 years following his dismissal to let him know of any suitable vacancies that they had within their business. And they had to do that within 7 days of that vacancy becoming live. So in my mind, that is a real, that's a real commitment that is quite onerous. And I think we can see the way that the tribunals may be going. I mean, I think they're trying to say to us as employers, do this right. Well, not only am I going to award quite a large element of compensation about you, but I would also make it that your business really focuses on what it should be doing going forward. And I may well put in place some recommendations that are going to really focus your mind on steps you need to make to ensure that you do actually create that level playing field, that you bring people with neurodivergency into your business and you treat them fairly. So it's a pretty draconian recommendation, but the AA are now stuck with it. And for 2 years after Mr. Lloyd Penny left, they've got to write to him to say, we've got this vacancy. Do you want to apply for it? Okay. So I'm conscious 10:53. I'm going to get through the rest pretty quickly. I want to flag up menopause and aging. There have been a couple of studies recently that have suggested that the menopause can have the hormonal changes that go with menopause can have an impact on exacerbating the conditions that divergent employees suffer from. For example, those with the menopause may find it harder to mask their struggles during menopause due to increased symptoms, whether it's ADHD, dyslexia, or autism. And there have been findings that women, for example, who are going through the menopause have not actually realized they've been neurodivergent until they got to the menopause stage, they realized that they were suffering. They went to see a doctor and they were actually diagnosed with some form of neurodivergency. So menopause in itself can actually flush out some forms of neurodivergency. And in relation to age, neurodivergent employees may experience age-related cognitive challenges differently to neurotypical employees. By this, I mean they may suffer from more pronounced memory loss and difficulty to focus as they become older. So these are points we need to think about and issues we need to be aware of. Menopause and aging can actually have an impact on those who are neurodivergent in our workplaces. I'm going to hand over now to Charlotte, who's going to talk about the third part, which is the practical steps about how we can make our workplaces better for those people who are neurodivergent.
Thanks, Tim. Yes, so how can we build more inclusive workplaces for employees with neurodivergence? So to start with some practical considerations, some of these also are fairly easy to implement. It can be things such as providing meeting agendas in advance and following up meetings with a list of concise action points so that everybody understands the outcomes, they're well communicated, and they can be referred back to. And other things such as providing maps or clear information about office space and social norms in the office, such as when and where to go to work, to go for lunch. Also the provision of things such as quiet rooms or well-being rooms that anyone can use can be particularly useful for individuals with sensory issues. And likewise, providing assistive technology or noise cancelling headphones can also assist some employees. And employers can also assist by doing setting up things such as awareness days and campaigns to help educate employees. And this is really important to highlight the importance of all employees being educated on neurodiversity. And likewise, things such as staff networks or disability committees, which can allow employees to share experiences, support each other, and also raise issues collectively that they feel need addressing. Next slide, please, Tim. And then also the kind of ask and listen actions that can be taken to help build a more inclusive workplace. So employers should actively listen to employees and encourage them to speak up so that they feel more heard and understood. And this can include things such as creating safe spaces where employees feel comfortable disclosing needs without fear of judgment or any negative consequences. It's important that employers don't take silence as a sign that everything is fine. I think both Tim and I have mentioned that often employees can be kind of trying to cover up symptoms perhaps or mask them as much as possible and kind of soldier on, as it were. And often having more open conversations can help tease out particular issues that employees are having at an earlier stage before it kind of snowballs and can become a real issue and have a real impact on both the employee and the employer. And other things such as asking employees how they like to communicate and using preferred communication styles. So, for example, not overwhelming an individual with ambiguous instructions or rushing conversations, as neurodivergent individuals often find this very overwhelming and it can create uncertainty and cognitive overload. And likewise, employers, as far as possible, should be prioritizing individual experiences by asking open and respectful questions and not going for a one-size-fits-all approach. Don't assume that what someone needs, as neurodivergence can vary widely. Thank you. Next slide, please. This is Tim. You're on mute.
Okay, final slide for me today. So some practical steps. What can you do for existing employees and in recruitment? Well, for existing employees, be aware of and know how to deal with neurodiverse conditions. It's been an interesting, journey for me as an employment lawyer, understanding more about neurodiverse conditions. I've done a lot of outside reading, and I've learned a lot. We all need to learn more about the different types of neurodivergency. We can implement low-key informative training amongst our teams. I think the key here is low-key. I think those who suffer from a neurodivergent condition do not want to be singled out, so the training must be low-key. Hold two-way problem-solving discussions to actively listen to what employees need. Quite often, speaking to somebody and finding out how can we help you will go a very long way and will be very much appreciated. Consider having agendas for meetings and turning on closed captions on video calls. Consider methods of communication, providing clear instructions in writing. But above all, be patient and open to learning. I think a closed mindset is one that is not going to take us very far at all. And we all know that closed mindsets lead to division. And I think in this modern day and age, what we do need to do is we need to be open to the fact that we have many different people in our organizations with different needs, and we need to accept that. In recruitment, use non-traditional, non-interview based assessments and training processes. We've talked about the case earlier of Miss Brooks. Vary your recruitment process. Allow all answers to questions. I think somebody could have sat down with Miss Brooks and said, right, 20-minute Teams call. We're going to ask you some questions. And I think they could have made a good decision on the basis of what she'd said to them. She would have gone through to the next stage and they wouldn't have ended up in tribunal. Remove exam and university result requirements. It may well be the case that those who are neurodivergent didn't follow the traditional route through school and university. Do you really need those exams to see who's going to go through to the next stage of a process, or indeed who will actually get a job? If you're not comfortable with your job adverts, use external experts to look at the language you're using in job adverts and ensure the language used is as inclusive as possible. We talked at the beginning about language and how important it is. Inclusivity is key here. And finally, allow candidates to visit the offices and meet interviewers in advance. Those with neurodivergent traits may well find it very comforting to do this, and a 5-minute, in advance team call with the HR department can often go a very long way. Support managers to get the best out of neurodivergent staff, implement awareness training for them, hold two-way problem-solving discussions and listen to their needs. It's important to say that as well as the neurodivergent staff in your business need assistance, because this is an ever-evolving area, do also factor into the account that managers may not know a lot about this and may not know how to deal with neurodivergent staff. So we need to support them as well. And a number of other suggestions. Consider the method of communication for instructions, and just think about the reasonable adjustments that you as an organization need to make. As Charlotte talked on earlier, they're pretty broad. There is no list of what reasonable adjustments need to make. And ultimately, when you're talking about reasonable adjustments, sit down with the individual, talk to them, find out what's going on, find out how you can assist them, and if need be, go to occupational health. Occupational health are now much more switched on to neurodivergent traits now, and they should be able, a good OH should be able to give you a good list of reasonable adjustments that may need to be made. Okay, we have gone over a bit. Thank you very much for staying with us today. Emma, do we want to, I will stop sharing now. Emma, do we want to have a look at some of those questions that come up in the chat?
Yeah, absolutely, Tim. I'm honest to God, we're both sat here, we're chatting away, And I think the enormity of this has probably struck all of us this morning, because I think, you know, we keep talking about this modern day and age, you know, and when we were all going to school and what have you, it wasn't given the recognition that it probably should have done. And you now see it. And I mean, it was even just something so sort of small and trivial, but just watching MasterChef a couple of nights ago, and you looked at Heston Blumenthal, who's been through ADHD, and he looked a fraction of the man he used to be. And you're just looking at actually how he was championing neurodiversity in the workplace. And I still feel we need to know, I mean, today has been fantastic because it's just put such spotlight on neurodiversity, but I think the enormity of it has actually probably struck us in terms of what we need to have into play. But also, I think the cases you were talking about, Tim, as well, there was so much complexity in those. You were actually looking at so many different elements of case law brought into play. So I think we're all feeling that was so amazingly simple. You know, it really clarified what we needed to do. But I still think, as you said, it's growing. You know, it will be very, very interesting to revisit this probably in a year's time and just look at those cases and see, you know, actually what's coming from them. Some really good questions, actually, that I've been sort of picking up on. And you've actually answered quite a few of them in those last 3 slides. But if we just touch on the first one, one of our guests here was actually saying that they've had basically somebody in a role, and that person has asked for a PA, which obviously has got a cost implication to the business. And we're just looking at the question here, it's about 60% capability that they're being able to do the role. But obviously you do look at it from a business, a commercial point of view, and the cost implications of that. What should that business be doing?
Yeah, it's a good point. I mean, tribunals are not, you know, they're not as draconian as sometimes we might think from the headlines we see in the papers, and they will factor in commercial sensibility to this. So the key is the word reasonable. Not all adjustments are reasonable. You know, if you could provide something to this individual to help them undertake the email responses, provide some software, for example, that would be a reasonable adjustment. However, if you've had a look at reasonable adjustments and they can't do a large proportion of their job because of their neurodivergency, then you're probably in the territory where you're going to sit down with them and say, we've looked at all the reasonable adjustments, we can do X, Y, and Z. However, we're unable to do what you're requiring because it would just have such an impact on your role, and we can't find any other way around it. And therefore, we're going to have to either look at moving you to another role or potentially, you know, reducing the hours that you do in that role. But it's all about consultation. It's all about speaking to the individual, talking to them about what's reasonable, what are the impacts they're looking, you know, the impacts on their role that their condition may have, and talking to them and hopefully finding a way through this, which is acceptable for them, but also acceptable for you. But ultimately, if somebody cannot do their role to a great degree or large chunk of it, and you've looked at reasonable adjustments and you've consulted, then you're probably into the territory where you're talking to them about changing their terms and conditions, as opposed to disciplinary.
You're okay to do that, aren't you, Tim? That's okay to do
that. Yeah, absolutely.
Yeah, there's another question, actually, a similar one, where an employee is doing a lot of phone work and finding it enormously stressful, and now absences have started. And obviously, from a business and a commercial point of view, that's not sustainable, which is absolutely understandable, because it's the key part of the role. So would you say it's similar advice in that respect?
Yeah, it's all about medical opinion, finding out what the issues are, finding out what adjustments can be made, finding out whether the adjustments that can be made can help the individual to then improve their attendance. And ultimately, at the end of the day, if you've got medical advice, you followed it, you put adjustments in place, and still we're seeing poor attendance, you then can see the path towards a capability type dismissal further down the line. Because ultimately, no tribunal is going to say that somebody can sit at home not doing any work indefinitely. We all know people who are left sitting at home doing no work because, you know, the HR do not tackle the issue, but good HR will be on it, will tackle it, speak to the individual, will get medical, opinion, and hopefully that medical opinion, working in tandem with the company, will allow the individual to then get back to the office and become that employee we hope they can be.
Yeah. Yeah,
You know,
and you mentioned
really,
actually something, the PCP, isn't it? Policy, criteria, procedure, that I jotted down here.
Yeah.
And it's actually looking just another question is neurodiversity actually featured in the Employment Rights Bill Act before?
No, I mean, God, the Employment Rights Bill is very thick now. It's getting thicker by the minute. I don't know anything in particular where neurodiversity is specifically mentioned in it. There's enough in it as it is, and I think the Commons have had enough of it already, and I don't see anything specifically relating to neurodiversity be included in it. So the answer to that is no, I'm not aware.
Okay.
Charlotte, are you aware of anything in it?
No, I don't think there's anything within the bill that relates specifically to neurodiversity. I think some of the changes that are being brought in may impact employees with neurodiversity. So things such as flexible working requests are going to be kind of harder, I suppose, for employers to refuse, because any refusal must now be reasonable. So where you have perhaps an employee with neurodiversity who's making a flexible working request off the back of their additional needs, an employer they're gonna have to look at not only the reason for the refusal but whether it's reasonable. And also, I suppose, the unfair dismissal day one rights that are going to be kind of the headline flagship policy, I suppose, for the Employment Rights Bill. It's anticipated that as part of that, the government will bring in this kind of statutory probationary period of around 9 months. That's what we're thinking will be brought in. And within that period, it will be easier for employers to dismiss an individual, for example, capability performance. But that will give employers a much tighter time frame where you have a new employee in the workplace and you need to and perhaps it's not instantly a right fit. There are some kind of issues that are coming up to assess whether that's because of a neurodivergent condition, whether that constitutes a disability, what reasonable adjustments can be made that work for the business, and if not, has there got to be some other conversation about an alternative role or perhaps even a dismissal or reduction in hours. Employers aren't going to have very long to get through that process under the Employment Rights Bill. So that could create quite a lot of pressure, I think, on employers.
Yeah.
That's interesting, actually, because I wrote down here capability as well. It's exactly what and I think, with this 9-month window now, we'll all be looking at that in terms of managing it really, really tightly. And then obviously making sure that we've got the right sort of policies and procedures in place, within that time frame. So, no, fantastic.
Yeah.
Somebody else has just asked, actually, sorry, Tim, somebody else has just asked about, in relation to tribunal claims rising, do we have any statistics on how many of these were successful claims?
Top of my head, no, I don't. We can have a look into that, and we can have a look into that.
Yeah.
I've just seen a question here from somebody. Thank you for pointing this out. The presenters are sometimes not using language in the way they advised. Yes, I realised that as I was going through it. They said this illustrates that habits are hard to change, even when the intention is pure. And I think this is a really great point this person's put. So thank you for raising this, and thank you for picking me up. None of us are infallible. And their question is this understood in the eyes of the law, i.e., if we do get the terminology wrong once in a while? And I think the answer to that is yes, as long as tribunals can see that it's a genuine error. If there's any malice behind it, if there's any ill intention, then I think the answer is no. But I think as we're all struggling to make sure our language is proper and the right language, I think if we can prove to a tribunal that our intentions are good, then I don't see that being an issue with the law and a tribunal claim. So whoever raised that point, thank you for picking me up. We all need to pick ourselves up once in a while, and thank you for raising that point.
I did love it though, how you said that one of the first slides is not the disorder, it's who I am. I thought that's really, I thought if we all keep that in our minds, I think it probably will change. But it is, I think it's just been given this spotlight now. And I think everybody's and realising, like I said at the beginning, the enormity of it really. So
well, that line came from I was acting for a claimant, and that's one of the first things she said to me. She said, very frustrated. They're doing this, this, and this. You know, it's me. It's just who I am. It's not a condition. It's me, and that stuck with me. And so that's why I put it in the slides.
It says a lot, says an awful lot. There's quite a few questions as well around recruitment, Tim and Charlotte. I think everybody's sort of looking at very much the selection process. There was a really brilliant question here about one of our guests who was saying that they were asked for questions up front. And we're talking about it being a fair process, but actually, is that fair? And are you giving is it a reasonable adjustment, or is it an advantage? I suppose that's the question in a nutshell.
Yeah, well, I think the obvious solution to that is yes, you should be giving questions in advance, but then if to make it a level playing field, excuse me, provide everyone with those questions.
Yes, yeah, it's true, isn't it? It is actually, it's equality, isn't it?
Yeah. I mean, don't forget that discrimination can be it can be the reverse. It could be, an able-bodied person saying that somebody with a disability is treated differently to me. So we treat everybody the same. And if we need to send out questions in advance, send it to everybody. And therefore you can't be criticised by anybody.
No, absolutely. And I think what we've done is we've summarised a couple of questions there, but I'm just tapping on one or two more. In case study 1, if the job GLS were recruiting to involve the successful candidates doing lots of multiple choice tests in their job, in a system that couldn't realistically be changed by GLS to remove the need for working with multiple choice, would their response to the request to change the application process have been more acceptable?
Potentially, yes, because that's you look at the legitimacy of the decision and your proportionality. And they fell down on the proportionality point. Was it proportionate to stop her doing something different as that first stage of the interview process? And on the facts of the particular case, it was. But if the role specifically needs you to test somebody's ability to do multiple choice tests, and you can prove that it's a key part of the role, then potentially you could go back and say, I get your point. I understand why you need to make your adjustments, but for this role, we need to assess your ability to do multiple choice. And it is a key part of the skill we need, the aptitude we need. And therefore, for that reason, we do actually need to see whether you have that ability or not.
Okay. And then finally,
and that would have gone over the proportionality hurdles.
Right, okay. And I think that so we summarise one or two, but finally, it would be good to understand a bit more about Asperger's and how those that say they are autistic refer more to Asperger's. Big question.
Yeah, big question. And, I'll be honest, and I don't fully know the answer to that.
Yeah.
I think this goes back to the original point, which we all need to know as employers and managers and business owners and HR advisors. We all need to know more about what these conditions are.
Yeah.
Okay. We're never going to be doctors, and we're never going to be occupational health. But as owners, managers, HR advisors, we do need to know the basis of what all these conditions are. And I'm always looking to fulfill my knowledge and boost my knowledge. And I think a takeaway from me today is learn a little bit more about Asperger's, because that's been raised.
Absolutely. Just a final, I know we're way over on time, but I just think these are really interesting questions. Is it mandatory to have a training to educate all employees, on neurodiversity? So some sort of training in place as a business?
No, I mean, I don't think it is mandatory, but if you're ever faced with a tribunal claim from a neurodivergent employee, you're going to be in a better position if you have trained managers.
Yeah, of course. Yeah, of course.
And hopefully, if you train those managers, you're not going to get to a tribunal. You're not going to get to that grievance. You're not going to get to that impasse and that communications block with the individual. But I don't think it's not mandatory to have that training in place, but it is one of the first things that a tribunal will look at.
Yeah.
Do you train staff? Do staff know, about disabled applicants? That sort of stuff. So I would say, with the age we live in, I think neurodiversity training is probably a must these days.
It's back to that PCP, isn't it, really, in terms of it being sort of throughout the business, and then the training, to support that, very much so. And final question, should a reasonable adjustments come from the employees themselves not from an expert who doesn't know that individual.
They can do, yeah. I mean, good consultation means speaking to the individual as well as probably getting occupational health advice.
Mm.
And then, you know, the two come together, you have the consultation meeting, you put the adjustments in place, and the employee's off. You don't, strictly speaking, you don't need to go to occupational health. If you speak to an individual and they say, you know, I know from my last job and my last firm, these are the adjustments that really helped me. If those can be put in place, great. You then don't need to go to occupational health. And if the individual were to say to you, the only adjustments I need are A, B, and C, can you help me? And you put A, B, C in place, then I think that's good evidence that, you know, you've ticked that reasonable adjustment consultation box.
Okay. Jim, this has been fascinating. I think we should revisit this next year, because I think it's just going to evolve, isn't it, really?
It's only going to get bigger, going to get bigger.
Yeah.
And the last point for me, people are more comfortable with raising it in the workplace, either to help others or to protect themselves. So it is going to become more open, and we've got to address it. We've got to know how to deal with it. And we've got to know how to help people who are neurodivergent in the workplace.
Yeah. Tim and Charlotte, will these slides be available to everybody?
Yeah, I'm going to send them out afterwards.
Okay.
So everybody will get a copy of the slides.
Wonderful. That's great. Absolutely fascinating. Bit scary, but actually the right thing. Feels very much the right thing to actually know so much more, and to make sure we're all doing what we need to be doing, really, and recognizing now, which based on those stats where you started, that this is something that, as you said, is only going to get bigger. So, Ali, should I get over to you with regards to, is there anything else, Tim, before we literally just let everybody know about the next event?
No, I'm done. Thank you.
Okay, wonderful.
So,
Charlotte and Tim, thank you so much.
Brilliant to see everybody again this morning. The next date for the diary is Thursday, the 6th of November, which will be another joint venture with RWK Goodman and Juice Recruitment. It is an in-person event, I think circa 7:30, 8 a.m. rendezvous. And this is at the fabulous location, which is 50 Supercars head office. Is this right, Tim?
Yeah, just outside Bradford-on-Avon.
And a really fun format in the way that, obviously, as I said, it's in person. It starts with some case law update often, usually a little quiz. There'll probably be breakfast and coffee, that sort of thing available, and good opportunity to network as well.
Yeah.
This is the annual employment law update, and it'll be a review of law over the last 12 months.
And invites coming out shortly, aren't we, Tim? We're getting the invites out shortly to everybody.
Thursday, 6th of November.
Yeah.
Absolutely. Topics we'll be touching on include how to handle DSARs, data subject access requests. We'll do an immigration update, and we'll do a discrimination case law update as well, plus other stuff. So it's always a good morning. It's lovely to meet people in person. I love Zoom meetings, but I love in-person meetings even better.
Yeah, absolutely. Really looking forward to that. I'd just like to say, Tim and Charlotte, that was absolutely fascinating. We thoroughly enjoyed that. I think we've all got pages of notes now that we're taking away, and making sure that we go and talk to the teams, and making sure we've got everything in place. And we're really looking forward to welcoming everybody on the 6th of November as well. But if you've got any questions, obviously, please don't hesitate to contact Tim, Charlotte, or ourselves. And we'd love to help. And obviously those notes will be going around to everybody as well. So
Thanks, everybody.
Thank you so much. Thank you for joining us.
Bye.
Take care. Bye.